We'll call the Collection Service Board meeting to order of April 11th, 2018. Everybody review the agenda. Is there any questions or any additions to the agenda? Let us know. And notice of meeting.
The notice of April 11, 2018 meeting of the Collection Service Board meeting was posted to the Collection Service Board website on April 4th, 2018. Thanks, sir.
Is the agenda okay with the board? Everything? Yes. All right. Okay. February minutes. Has everybody had an opportunity to review the minutes?
Good. We'll just go ahead and take a vote on the agenda just to kind of memorialize it as well. If anyone want to entertain a motion to that regard.
Second.
Moved and seconded that we approve the agenda. All in favor?
Aye.
As for the minutes?
Yes, sir. I wasn't here for the meeting. I did read the minutes, and but I will abstain from voting on the approval of those. I have to have a quorum to approve the minutes.
I don't believe so. We'll take the vote, and then afterwards, if we deem otherwise, we'll represent. But I don't believe so. Not with an abstention. I think we're fine. But if we, yep, you were here. Yep. It was
a couple of people were by telephone. I was by telephone
That's
for a
right.
minute.
You were by phone, and then you came in because
Yeah.
was horrible.
She helicoptered in on Easter. I remember. But yeah, we're fine. If we want to go ahead and vote on that, if the board so approves.
We'll entertain a motion to approve the February board meeting minutes.
So moved.
Second.
Moved and seconded. All in favor?
Aye.
Director's report, budget.
All right, that moves us to the director's report. We'll start with the budget. As you know, the budget's been a source of much discussion. We've seen some activity on both revenue and on expenses going in different directions, and so we'll just dive right in. As you know, we've tried to mitigate some of the expenses portion by looking at, as we discussed last week, we talked about those complaints outside the jurisdiction. We just won't refer those. And then with withdrawals, the board granted us the authority with those withdrawals, if there's not made under duress and a statement is in writing, and those withdrawals are, we deem those to meet that criteria, that then we'll withdraw those as well and not refer those. So, and then we'll discuss an agreed citation schedule later on in the program. But so that's how we're mitigating that. Now let's talk about revenue. This month, you'll notice in February, we took quite a big dip in revenue. If you've noticed the trend, we're looking at, I guess February wasn't so bad, but January is the one we're talking about. We had revenue of $8,000 coming in. Well, if you look at the months prior to that, we're in double digits all the way across the board, and then after that, we're in double digits again. So the issue here isn't expenses. The issue here is revenue. And what we believe that to be, after talking to our accounting director, is we had 10 renewals that were in the pipeline, and you can imagine at near $750 a pop, and that's pretty substantial. Well, what's that? 350, excuse me. Yeah, so we got 750, I guess, with initials and some of the others. But at that expense. If those renewals don't proceed, that was our dip. And what it came down to really was they were taking advantage of the exemptions. We have a lot of agencies that have since, upon renewals, realizing that they don't qualify or necessarily have to get a license, so they're exercising their right to proceed without one. So. That's one of the things that we're noticing, that we're noticing a dip in revenues as we go.
Those mostly debt buying agencies that are not renewing? Because
It's
the change
really
in the law where you don't have to, if you don't collect as a debt buyer, because debt buyers used to.
That's some of it, but a lot of it too is just those that aren't domiciled in the state. You know, that was kind of a surprise to me. We've noticed a lot of folks, so they don't qualify. They don't have to get a license.
But if they collect debts from Tennessee, they have to be licensed. If they're in New York and there's a debtor in Tennessee, then they have to license.
They don't need a separate license for each every agency or every
branch.
heading for what.
It's the branch. Most
Right.
of them don't qualify as a branch because they're not physically located within the state. So people who have been applying qualify as a branch.
If they don't have a physical location in the state, you're saying they don't have to apply or get a license if they call into the state from outside the state?
For their additional locations, their main agency has to be licensed.
Okay.
Right.
Okay,
So-
so they do have to have a license.
That's
It's
correct.
just the additional
But
locations.
if they have an office in New York and in Connecticut, they only have to have one license.
Correct. So
Okay.
what I've been telling them is to send me a letter with all their locations so we can status them under their entity.
Before, they were getting one for each. And the statute, 6220-105, says licensed collection service, a service maintaining more than one place of visit. So, yeah, they're getting licensed, but those additional locations aren't getting licenses now.
They have to have a branch license? Did we used to have a branch?
We used to, but it's only for physically located businesses within Tennessee.
Those are, I think, branch licenses. Last time I checked, were like 6 or 7. There wasn't a lot. They've really dwindled as well. So yeah, we're seeing a wide variety. There's I think once they look at those exemptions, they're starting to realize that, and of course the debt. You know, you have the debt buyers; they no longer are required, but also those that aren't registered, or excuse me, aren't within the state. So we're seeing a lot there, quite a few there. So with that correction, we're seeing a dip in revenue, and so which I would like to, while we're there, I think you've already seen the budget. You know kind of where we're at on that regard. I'll just read the numbers real quick, and then we'll shift about what we're going to do about the revenue, what some courses of action for us to take are possible, what we could potentially proceed with. Let's read the February numbers. We have revenue of $20,600. We have expenses of $11,800, which puts us in it looks like a net surplus of $8,700. For the year, we're tracking in a deficit of $17,000. You'll notice from the legal report here pretty soon when we go into, we've got a lot more cases, but some of those we did mitigate. But part of the reason why we have more this round is we're going to cancel the meeting or the next meeting, which puts us at August 8th. So we wanted to meet those metrics. So we just pulled everything out of the file that we had that could potentially expire and then presented you all at once. So that's why we still have a lot of cases this round, although some of that has been mitigated. We've seen some of that already. So just to keep that in mind as we go. But as for some things that we can do about revenue, part of the challenge when dealing with exemptions is we've noticed a lot of folks when they call in, some of these companies, they realize that they need a mortgage financial license only. They really don't need a collection license to begin with. So that's part of it. And one option is NMLS. The nationwide multi-license, or excuse me, NMLS is National Multi-License System, is how it's referred to. But the Department of Financial Services, currently they use NMLS for payday loans, mortgage lending, but it's available for collections. And one option is to streamline that process by putting all those lines together under one house. And so when someone calls in and they're not sure whether or not they need a collections license or not, but they've already got a mortgage lending license, they can have that conversation in one source. So we've looked at the system. You've probably seen the data sheet that I provided about what that offers. Something like that would require reorganization under the Department of Financial Services instead of the Department of or the Division of Regulatory Boards, and so that's a big shift. Obviously, that would require legislation and administrative approval as well. But we didn't want to even talk about or go any further if the board wasn't even in favor of that. So I wanted to introduce that as a possibility, one way to help with some of the revenue as well. To manage that and to make sure that we don't have any duplication of processes. If you have one staff already taking care of the mortgage licensing side and taking care of the payday loans, and then they could extend that to the 900 plus licensees that we have now. Well, you see the business benefit of that as well. Not that something we're necessarily advocating, but there are other states that do that. And I talked to the Maryland Assistant Commissioner who manages their license lines, and they're in NMLS as well. And that's what they did. They also put all the renewals on one cycle. So somebody has multiple license lines. They're on one renewal cycle. So they become one entity with several licenses. And one of the benefits, you've seen the data sheet, but one of the primary benefits of it is the functionality of it. You can, it also allows for you to flag parameters. Like if you have a potential bad actor, no matter where they show up, if there's application where they're connected, it pops. We can also do like a mini audit by setting parameters and say we want to look at these files. So there's a lot of functionality there. Plus you have the portal where you can talk to folks that have authorization to use the system, professionals on the other side, secure portal. So when you're on the phone, a lot of times you have to authenticate that you're talking to who you think you're talking to. Well, here you know because they had to sign on. So if they're in the system, you're talking to a licensing professional on the other end, maybe a regulator. And we have access to exams and investigations that we otherwise wouldn't have access to. If somebody finds something elsewhere, then we would have access to that information as well. So, and you're looking at about $100 for access to NMLS, paid for by the collection agency. However, if they already have an NMLS account, because of one of their other license lines, they don't pay that $100 again. They already have an account. They're paying the $100 already. They're paying for an application fee is what they're paying for. So that's something to think about. I don't know if that's something that the board would necessarily be interested in, but those were some of the things that we gleaned from the conference and from talking to some other states. So if there's something that the board would like to further discuss and explore, then perhaps we could get financial services in the room and then go down that route. So is there any questions about that in particular?
I notice another advantage, and we've talked about it, Glenn, is some states audit their collection agencies. I know Arizona does, and Steve, you may be aware, Nevada does. And then we would have the advantage of those audits. We would know how those are. And you mentioned a bad behavior in one state. We would notice that and see that with just a click of the button.
Our staff attorney Ashley and myself and Roxana and one of our auditors went up there to look at the system to see how it works. Financial services obviously is at Tennessee Tower, and we just were examining how that works and what benefits there would be. And once we realized the functionality and the information that was available to us, the benefits were clear. So
The application that we just redid online would be filled out within that system.
Yes, sir. It's a universal system. The application is the same for all the states. Which the standardization, so they go in the system, they type in all their information, and it creates an application. It's the same application that Arizona uses, that Nevada would use, that Maryland would use.
Not have some specific questions on the application that conform with our law?
We do. There's a state-specific addendum which they can add to that as well. So anything like that, they can cater that. It's completely, they can function that however we need to.
And NMLS is a nonprofit.
It is. It's owned by the regulators. It's completely nonprofit, and I put that in the data sheet as well because that's important. Yeah, you don't want the bait and switch. You don't want to come in introductory rate, and then you get hit with some fat fee down the pike. So that's one way that they mitigate that. They have to have the buy-in of the regulators who own it. They're the shareholders.
I personally like it, and I don't know when it would come to a vote or when we would discuss it more. I guess towards the end of the meeting here. To favor the future, it's what we have to do.
And that's we've dealt, and we're going to talk about what we're going to do about the agreed citation here pretty soon. I guess if I can get there. We get to the agreed citation guidelines. That was another way we wanted to plug the holes of the expenses. When we get there, we'll talk about that more. But NMLS was one option for dealing with revenue as well, besides just the efficiency of the system and the benefits to consumers to be able to have that robust initial audit. That's helpful. But beyond that, that was one way to help with the revenue as well, because you're streamlining all of it together in one house. So I mean, you could vote to memorialize your will that that's something you're interested in, or it doesn't have to be that formal. We could just, if it's the will of the board, we could proceed with the next steps, communicate. The assistant commissioner, he's aware of the information, but obviously we're not going to do anything with it until we had the board's approval first. If the board wasn't even interested as the industry experts, then there's no reason to go any further. And so if that was something the board said, yeah, we could, I'd like to look into it further, explore. We're not saying we're going to do it, but then.
Discussion time for it, or are we going to postpone that till later in the meeting, or should?
I think it's on the agenda.
Okay.
Yes, yeah. We're there now, because that was going to be my next point anyway. So
Budget, so we're
Yeah.
finished with the budget, basically.
we're done. Yes, sir.
What's the downside to the system? What do you see as problematic with it? Surely it's got something that's not pretty.
The only thing that I saw was the cost initially. I didn't like that. Initially, that was my first.
What is the cost?
It's $100 for per year passed on to the collection agency, the licensee.
Doesn't hurt us.
No.
We need help with the iPad up here.
Oh, yeah, sure.
Sorry.
No, it's okay. Yeah, sometimes you got to go to the library. It's get tricky.
Dial up.
There we go.
Yeah, I think I had it, but I didn't know that's what we were.
Miss Thomas, she was there as well. I don't know if can you think of anything that just jumped out? Because we tried to ask some really tough questions. We didn't go in there just, and the thing is, it wasn't NMLS spokesman that gave the pitch. It was Department of Financial Services. They were the ones that are using it, have been using it since, I think it was like 2011, because it's like 7 years. Yeah, 2011. And so we pushed a little bit, because they'd been on the full gamut from onboarding to all of that. And onboarding was one question we had. We want to make sure it was smooth. And they said that they basically work. NMLS has a tech services, so they don't even have to use like our IT staff. I asked them, well, we get on the hotline, is it like calling one of our favorite telecom providers? Are you getting passed around 20 times, And you sit on the phone listening to music that you could probably do without? And they said, well, no, we typically get a hold of somebody that will, even will run reports for us, right there, and we'll give that to us as well. And so they said onboarding was pretty smooth, that they just do basically data dumps to transfer them over.
They take our application and put it into their system. They break it into the standard questions, and they have the addendum questions that are particular to our industry.
We'll do that through, it's a transition. I don't understand all the technical aspects of it, but they do.
They take in the financials and post those in the system so that they're available, because we have financials submitted and all those kind of things. Is that part of it?
It's part of it, because that was one of the things that we were concerned about. What we didn't want to do is maintain two systems. That was important to us. I mean, obviously, if you got to maintain two systems indefinitely because one's grandfathered in per se, then that's useless to us. We'll keep our old system and we'll work with it and just communicate the best way we can and do the blue book if we have to with our partners across the state lines. But we were assured by Department of Financial Services, not NMLS representative, but folks that have actually done it with their licensees, that they transfer them over.
Yeah, they transferred in 2009. That's what my notes
Mm-hmm.
say. My notes say the financial institution transferred to NMLS in 2009. Looks like there are 8 currently that have transitioned. And then it maintains the confidentiality nationwide. So it maintains our statute, our standard for confidentiality as far as financial information is concerned, that's maintained throughout the nation.
Well, the licensing fee would still be $750, but it'd just be an additional $100 for this in MLS.
For that system. Now, granted, if they've already got a mortgage license already or a payday loan license, something like that, they've already paid it. So they're not doing that. They're paying the application of $20, $25, depending on what that is.
What about the $750? So if you're a payday lender and you want to be a collection agency, you still have to pay the $750.
Right. And that was another thing that we liked as well. They actually take the payments for us and then cut us a check. So we're not even taking the payments. Once it's a complete application with payment, they take that. They take care of that for us as well.
What about consent decrees and that money? Is that sent to them as well?
You
Have a consent decree.
I see. Right. All of it would be handled through that system in conjunction with the department that has oversight as well. Now, obviously, one thing is if this is something the board would be interested in, we could coordinate some sort of tutorial with financial services so you could ask those kind of questions. And
Would it reduce our staff? Would it reduce our staffing needs?
It would.
For the Collection Service Board?
Well, because all of it would be going under one. Because you're not using IT staff, because MLS has its own staff for that. They take care of their own system. You've got, mortgage lending is a bigger license line, and so is payday loans, you can imagine, than collections agencies. So we're looking at 900 collection agencies. Now we can streamline under one staff already doing that. Now, Financial Services hadn't told us that they want to take it on, so we'd have to still. But we start with the board first. If the board of experts tells us that that's something worth exploring, then we take that and then up the chain to and also to Financial Services if that's something they would proceed with. And they may come back and say no for whatever reason, and then we'll share that information with the board, and then we'll know where to go from there. But it's kind of good to get around the dinner table and at least have that discussion.
Have you noticed anything that's negative about it that you don't think it would help our board?
We looked at duplication of process, and once that was ruled out, then we felt pretty good about that because that was a big one. I mean, the conversation's over if we got duplicating processes. There's no efficiency gained. And then we looked at fee. I mean, if it's a burden on our licensees, that's another issue. So then I talked to the one of the executives over there at Financial Services who was giving us the tutorial and asked him about that, just frankly. Yeah, and I said, his statement was they don't even bat an eye. They understand that's the cost of doing business, and they're working with the MLS in other states already. So typically, they already got the $100 taken care of. So they're looking at application fees. So, and if it means that they'll be able to streamline their processes as well because all their license lines are on one cycle, and those other states can communicate with Tennessee. A lot of times they don't have to fill out the same application because if they've already filled out the application in another state, remember it's standardized unless, of course, our addendum, whatever they have to attach to that. But then they could just forward that application, so they're not filling out another application. So there's efficiency for them too.
Another advantage that we would have if you got a bad operator in a payday lending business, that's going to be flagged. So when he gets a collection agency license, we're going to see how he operates.
We'll see it all. And you can also what another thing I liked about it is consistency. If they're reporting financials over somewhere else, you're not getting a different set of financials when they apply for this license line because I can see it.
Yeah, sure.
And so if they get audited, Minnesota, or they're in the process of investigation, then I see that too. I'm not just relying on their attestations, which historically we've had to do that in the past. So, I mean, when you look at the cost and the benefit, and then you look at our revenue situation as well, since folks are taking advantage of that exemption because they only need a lender license, you can see why we're having the discussion.
How many of our licensees generally are Tennessee-only agencies? Of the 900, how many agencies are there in Tennessee that are Tennessee agencies as opposed to outsiders coming in?
I wouldn't have that number in front of me, but I can tell you, give you a feel potentially. If Aisha, can you weigh in on that one? Because you see the applications.
Less than 100.
Less than 100 agencies operating in Tennessee, yeah.
There'd be 800 of out-of-state agencies that would coordinate out-of-state information. That is valuable because if there's only 100 in Tennessee, those kind of are not our main focus, but those are the ones we mostly regulate.
I think it's a great advantage.
I didn't realize there were that few.
Yeah. Where should we go from here, Glenn?
I think we'd have to first coordinate financial service, because then, once we get your interest in exploring it, then from there we'll coordinate with financial services so you can potentially even view the system. We may have to coordinate that around our next board meeting, perhaps, because there's really no rush on it right away, because we'd have to, it would in effect be a merger, right? And so if that's the case, then that'd have to come through statute, which we're already past this legislative cycle, so we don't have to do it, immediately. But at our next meeting in August, since we're skipping the next meeting we have on the schedule, then in August, potentially after we leave here, I could schedule something with financial service. You could look at the system. I mean, they're right down the street. Shuttle you guys over there, take a look at it, if they were willing to do that. And you can hit them with all your questions.
Do we need a motion to proceed?
I think that'd probably be healthy, just in case anyone wants to know, in case that needs to be memorialized. That'd probably be healthy. That would be your intent, to pursue that further and explore it in conjunction with financial service on that effect.
Say that we would have to move under financial services as opposed to who regulates us or who we report to now, so we'd be part of that.
Yes, sir. It'd no longer be regulatory boards, but you would be under financial service. It's a different department. That's the difference. You're looking at the departmental change.
What effect does that have? I mean, why are we under what we're under as opposed to financial services now?
It happened years ago when I guess it's 71 or the statutes just put us under regulatory boards.
When they established the board, the legislature decided to put it under commerce and insurance rather than financial institutions, and so to change that, you need a statutory or a legislative change to change.
Interesting. For what we do, it seemed like would have been put under financial. Just generally, that seems like a more appropriate fit for the nature of what we regulate.
Well, as I was having those conversations with their executives over financial services, I was thinking the exact same thing, just in conversation. I mean, they're using the same terminology. They're talking about the same actors.
Commerce and insurance, what does collection have to do with that?
Right.
We're not selling policies.
Right. So, and really, and we didn't go there first. NMLS brought us there, because I looked around and who's using NMLS first. I don't want to talk to their representative. I want to talk to someone that's using it in the state, And then when I found out financial services was using it, and then I saw that they're using some of the same folks that we're already licensing. To me, that's when we went to the. And then after talking to Maryland Assistant Commissioner, they have all their license lines under one head administratively and through NMLS. Then it was a no-brainer. Then it was at that point it was worth the discussion.
We're not like a barber license,
right?
We're just not. I mean, beautician license. It's just not.
The other interesting thing too is I'd never heard. When I think of MLS, maybe you do too. It's multiple listing services, and Glenn and I heard about this in MLS at our meeting in the car meeting, and it just goes to show we could have been doing this since 2010 or 2000.
And that's one of the things they were changing the name of it. It was nationwide mortgage licensing system, but they're changing the name to nationwide multi-state licensing system for the reason we're talking about. A lot of other states are coming to the same conclusion that we're now coming to, that why are these separate departments? Let's put this group together. I mean, they're dealing with the same licensees. They're dealing with the same sort of industry, the same sort of the terminology. It just makes sense. So that's what they're doing.
And bad actors pop up in all those locations.
That's right. Sure. So even NMLS has changed their name to adapt. And so, and other states are doing the same. So, there's a few states doing that. Maryland is leading the way, and that's why we had that discussion with them. And then the CARA vice president was the one that we talked to. Bart and I were introduced to him, and since I knew they had all their license lines under one, he just seemed like, and since he's already at the assistant commissioner level, just made sense, since they've already been through the process, to throw our questions at them as well. So once we did that with financial services, and then we did that with the assistant commissioner in Maryland, that's why you have the information before you today.
Entertain a motion that we proceed and to explore our operation through financial services with the NMLS.
So moved.
Second.
All in favor of the motion, say aye.
Aye.
Okay, good.
All right, thank you. I guess then we can move to the last piece. If you remember last meeting, we talked about reducing our legal expenses and legal cost backs, and then we already touched on the first two, withdrawals, and we moved on that, and also things outside the jurisdiction just won't be referred. So we're going to save money there. So today we're going to talk about the agreed citation. We talked about maybe just providing a primer for discussion. This isn't the finished product. This is just to get the conversation going. So if you don't like any of these, then we can scrap it. If you like some of them and want to tweak it, we can do that too. Or you want to add some, we can do that. But this is just to kind of give you an idea about what we're talking about in the first place. And I thought I did, but maybe not. Okay, so if you want to take some time, then just look at it, and then whenever you're ready to have that discussion, we'll do that.
Okay, let's read up.
Basically, you're talking about mandatory sentencing guidelines?
No, it's more like a ticket. If you get pulled over on the side of the road, they give you a ticket, right? And you can pay it and settle and be done. If you think you did it, and then you can pay and be done. That's what this is. If you don't think you did anything wrong, then you can go through the complaint process. That's what this is. You can go to the judge.
And would you send this to me and maybe the other board members?
Absolutely.
Who may want to have this.
I absolutely will.
What is there something that we need to decide on today?
No, sir.
I'd like to have an opportunity to read through this.
When you say citation, what range of things are you cited for? Just all the things we do already in all the cases?
If Ashley could kind of expand on that, I'd like her to hit the high notes too, so when you're reading it, you understand kind of what was in our mind and where it came from. I think that's helpful too.
Right, yes, please do that.
Right. Excuse me. I think Glenn explained what the citation process is pretty well. If you'll look at page 2, what I've done is I looked at some of the complaints that we receive in legal, what are the most common, and then I know we have some proposed rules. And what I did was I pulled a few of those violations that I think centralized complaint, that department could look at those and see and issue those citations without needing the board's expert review of those cases. And if the person for whom they're being accused of this activity, if they agree to it, they'll sign it and send it, and it's never referred to legal, it's never presented to the board, and then that cuts back on the legal costs. Like Glenn said, if they disagree with that, then it follows the complaint process. They get an opportunity to have Dennis review it legally and present it to the board. These are just a few of the violations that I pulled. Of course, once the rules go into effect, I believe they'll go into effect June 5th, barring any request for hearing. The board can add or remove these. Unlicensed activity, I know a lot of times some of the other boards prefer to see every single one of those complaints. If you notice, I did indicate unlicensed activity where the activity is unlicensed due to an easily corrected error. So if they are unlicensed because they engaged in activity past their expiration date, that's something maybe we can cite them for rather than true unlicensed activity that the board may want to see. Again, the board has the decision whether or not that's something they want to put on an agreed citation schedule. And then the other suggestions, again, came from the rules, just attempting to communicate with the consumer at an inconvenient time. I think centralized can see that, and they can look at the complaint that says he contacted me at 9:45 p.m. We don't really necessarily need the board to review that. They can send that citation to that collection agency, and they can settle it that way. Like Glenn said, you are free to add or remove from that, but those are just some of the ones I looked at. And then the final 2 pages are examples of what would be sent to that collection agency. So for the first citation, we would do a warning letter. And so Exhibit A would be what they would receive, letting them know we got this. There's no dispute to it. We're closing it out with a warning. If it happens again, they would then get that citation, and that's what they would sign and send in with their payment.
Is the first citation just a warning? Why not like a nominal $100 fee?
And it could be. That was just a
little bit of pain.
Mm-hmm.
Yeah.
Right. And if that's a change the board wants to make, we absolutely can do 100 for first. And it doesn't have to necessarily be 3 citations before it comes to the board. If you want it to be first citation, the next time we get a complaint about that same activity, we bring it to the board. All of these things are things the board can
So
change.
first and second, beef up the cost of the second, and third, they come to us and we jump them pretty hard.
If you want to, when I send these to you, as soon as we leave here today, I'll send those to you direct. When you get those, if you want to carve them up, write all over them, and then send me some of your revisions that I could present, in open forum, we can do that as well.
If you had an agency that, say, called them after 9 p.m. and then and you sent them a citation, and then that agency communicated with somebody other than the consumer, would that be also one citation, or would that be the second?
That would be, so it would be a citation for each of those offenses. So it would be the first citation for communicating after 9, first citation for other than consumer. So we wouldn't combine them in that way.
So one act could be 2 citations, like they make the call at 9:45 and talk to someone other than the consumer.
Yes.
Okay.
But if one day they called after 9 p.m. and we sent them a citation, and then down the road we get a complaint on the same agency for communicating with somebody else other than the consumer. Citation.
Right. That would be a first citation for that activity. So citations would be categorized by what the activity is rather than by the licensee. It's not the number of citations you have, it's the activity that you're being cited for.
I don't really like that personally, but I think if they do something wrong, that's the first, and if they do something else wrong, that's the second.
That me too. A lot of what I look at on the legal report is previous letters of warning, and because it gives me an idea about what kind of actor this agency is, and I think that if they get a warning for one thing, then the next letter would be tougher, a second citation.
That would make sense to keep 3, because the way we're talking about it, just 2 and then come to the board would be plenty. But if any citation is an offense, then you could have 3 offenses and the price gets pretty high, and then after that, everything comes to the board. That would be more reasonable to me.
And where you have multiple offenses in one event, you could get there pretty quick anyway.
Well, that's a single citation.
Right.
They do 2 or 3 things wrong at once, which isn't hard to do. They've just that's a singular error time period. But if they do it again or something like it.
And again, and if Centralized received that and they saw multiple violations there, I would imagine that they would probably contact me via email and say, I see 3 here. Do we want to go ahead and refer it to legal and have it just brought before the board, or are we okay to send the citation? So that's also something else that the board could think about as it relates to that.
And those type of things aren't just assurances that we make because that's what they do historically. We write that in their SOP. So we would memorialize that and inculcate that in their SOP about what their instructions are in regard to those guidelines.
Just an offense is an offense. Doesn't matter if you've done the same.
Sounds like once you get done carving that up and then send us back those responses or those edits, then we'll have something to work with, and we'll present something, a second draft, and then we'll have something more to kind of sink our teeth into.
Okay.
And I just wanted to say just one final thing. Absolutely don't feel limited to what I've listed there. If you look at the rules and laws and you see other things that you think maybe could be added as a citation or that you don't want there, please let us know that as well.
I think unlicensed activity, and you mentioned it before, but I think unlicensed activity is the worst offense. that you can have. We have agencies out there that walk through fire to stay licensed and do the right thing, and then you got an actor out there that doesn't even apply for a license is bad. And I'm thinking maybe citation to that guy, he needs to come to the board.
Well, and that's why she clarified where the activity is unlicensed due to easily corrected error. Like if it was like their license expired, and then it was a short lapse, then that would be. Now if they just didn't even get a license or try, then that's a whole different ball game. That wouldn't even be on the at that point. We could carve in some exclusions as well. Yeah.
Any more discussion?
So you're going to send us something and you want us to respond back?
I'm going to send you what you have on your iPads there, and then just send me your revisions, comments, just to me personally, and then I'm going to put all that into one more document that at the next board meeting in August that you can look at, and then we'll have a second draft, another primer that we can really massage until we get it where we want to be.
Okay. Legal report. Have Ashley and Steve, have y'all had time to look at the read the legal report?
Yes.
Okay. Is there anything you want to bring up about specifically? Well,
Items to change.
surprisingly enough, I noticed in the report overall, we have traditionally, at least, fined an agency for unlicensed activity, and these are letters of warning. Is there a reason for that?
A lot of warnings. There were no fines for it, no matter what it was. I don't think we fined anybody.
What I had found over the course of just my brief time on the as disciplinary counsel is that many times the unlicensed activity comes sort of on a first, either it was their first time or it was the first time in many years. And I think that was sort of my math in coming to a recommended disposition. So at least for this report, that was what I found, where if there was unlicensed activity, it was their first time, or as in our previous discussion about maybe doing agreed citations and whatnot. But that was why you see the number of the recommended letters of warning. I mean, certainly anything that we've recommended a letter of warning for, we could have also have recommended a civil penalty of $100, $200, whatever the range would allow us. But yeah.
Number five. This is a company that's operating without a license, and I would first of all recommend that we have an agreed order with a $500 fine for collecting without a license. And the other thing that kind of disturbs me about this is if they have clients that they're working for, and those clients have hired this agency to do collection work for them, then those clients are in violation of our act also for hiring an unlicensed agency. I don't know if it's within our purview to ask these unlicensed agencies, in particular number 5, his application was denied. If we have a right to know who his clients are and send them a letter advising them that the agency that they've hired is not licensed.
Yeah, we could probably do that.
We can ask. I don't think we can force them.
Yeah, I'd agree. There'd be no way to compel them, but I mean, you can ask.
Yeah. Board as a group agree that there should be a fine for this guy?
Number is it?
Number 5. His application was denied for whatever reason. Still collecting.
Oh, yeah, there should be a fine. He had all the knowledge he needed not to do it.
Yeah, he applied for a license and he was denied, so he knew he wasn't supposed to be collecting. $500 is agreeable?
Yes.
Okay. Number 6, same thing. Only this one, not only, well, I'm not sure, maybe one of our lawyers here could tell us, if they're not licensed, do we have a authority to fine them for failing to respond?
We do. If they don't respond to the complaint, there is statute that says that failure to respond constitutes an offense, right?
Well, here we have number 6, that he's unlicensed collection agency, and he also failed to respond. I would think $1,000.
Didn't apply for a license and got turned down, whereas the other one we charged $500 did. So the other one had much more knowledge of what he should or shouldn't do than this guy, probably.
But this guy said he at one time held a license, but it's now expired.
You're number 6.
Yeah.
The other fellow.
Right.
Okay.
And then $500 for unlicensed activity and $500 for failing to respond.
Okay.
Sounds good to me.
Number 11, the same thing, even to the point of his response is that he's now closed the file, meaning that he knows what he's doing and he knows he's doing it without a license. $500 okay?
Yes.
$12, same thing. Like he's collecting checks. Plus he's reporting it to the credit bureau. Now that reporting to the credit bureau specifically is not an effort to collect, but here he is reporting this guy's debt to a collection to the credit report, and he doesn't even have a license to be a collection agency. $500?
Yes.
Number 14.
How can you report something that's not your debt to the Bureau? The furniture store could report it, but it's not even his debt to report to the Bureau. That doesn't make business.
I don't know, but that would be up to the Bureau's internal controls. They ought to be dinged too, but that's not our...
What number did you say?
We're on number 14. It looks like he failed to reply, failed to respond, and it says that the respondent is a licensee but did not respond. The complaint was received and signed by someone in the at the respondent's address. So somebody received it, but they didn't turn it over to the right person to have it, to make a response.
Letter of warnings.
Letter of warning, good enough?
Yeah.
Okay.
It may not be an overt act to ignore us.
Yeah.
Administrative person just didn't carry through.
But we see that quite a bit, where that you have one location that receives it, and then it takes maybe 7 days to get it to someone at the other location who's responsible for responding to these kind of things, and then before you know it, it's 30 days, and we look at it as, well, we just don't have a response, so.
Now that is he aware that he didn't respond?
I couldn't tell you.
Okay.
If we sent them something, that'll prompt a response, especially when they see that it involves either a consent order or and sometimes you don't get any response from a letter of warning, because I think they just take it as, okay, we learned our lesson. But when they see that there's money involved and they're going to have to sign a consent order, which then could potentially impact their their insurance and whatnot, then they'll respond.
That's what I'm looking for, is the response to the original complaint.
We're still on 14.
Yes, sir.
No, there's been no response. Unless, and you know, it's possible I could open up the file and see if there's been anything, you know, that's come in as of late, but I doubt it, really.
Could our letter of warning also tell him that we're still waiting his response from the initial complaint?
It could, yeah, it could.
Number 17, just a question. What is an LCD?
And that's one reason I put that in quotations, because I
You
really
don't
wasn't
know
sure.
either?
It's got to be some medical insurance abbreviation for something. But I mean, you could probably guess 2 or 3 versions of what that might be. I would say the D is a denial, but what the L and the C stand for, I'm not
That's all right,
entirely
yeah.
certain.
Google says it's local coverage determination.
Good for you. It's amazing what Google will do for you. Number 30. It seems to me that payday loans cannot be sued. Do you know that? Can you sue somebody in civil court for not paying a check advance?
I have no idea.
I think it's just part of the statute that you're not allowed to sue somebody that payday loan, a check advance loan is not suable.
The check wasn't made for payment, it was
In any event, it's a debt that's owed, and you could take it to General Sessions Court and attempt for a judgment. But I believe the payday loan statute prevents those cases from being sued.
Didn't realize that.
Would look that up and make sure that that's the case, because if it is, then he's threatening something that he can't do.
So let me make sure it's your recollection that the payday loan statute prevents a civil lawsuit to collect fine obligation.
Yes,
Which is the advance check. Is they write a check in advance of it being due, and then when the check is due, it's not honored. Can they sue on that check as a bad check?
or no, well, not
interesting.
even as a bad check, as any kind of debt at all. It's not a bad check in the criminal sense, for sure. But even if you want to sue somebody because they didn't pay their rent, that's fine. But I don't believe you can sue people for having a payday loan.
On that.
And then the account was sent to a collection agency lawyer, and obviously the collection agency lawyer knew that too, and he didn't even send out a collection. He didn't even intend to. They're threatening to sue people, and they're not allowed to sue people, then that's obviously a violation. So maybe we could bring back number 30 to our next meeting? Okay. Well, I had some time to sit at home and read these. Number 35. If we could, we don't know that it's a collection agency or not. If the complainant could send us any communication that he's had from this so-called agency, then we could tell whether or not he's pretending to be an agency or not.
Right, and I think what I recall from this is the complainant had only been receiving just phone calls, so.
Well, been phone calls in that, but nothing we can do about that. However, he is collecting without a license. Yes.
That's the thing, if it truly is,
Yeah.
it could be anybody on the other
Yeah.
end, that's but at the same time, if it's someone who's, attempting to collect a debt, then, I think that's still considered to be unlicensed activity.
Very well could be their own debt, which would not be unlicensed activity. I mean,
Right.
just somebody from a store calling saying, hey, you need to pay us.
Right.
That's far from
that's
unlicensed.
outside.
Yeah, we don't even have enough to know if it's a third party as opposed to the original lender.
But we don't know. That's what we don't know.
Yeah, so.
Maybe maybe we should flag this to see if we get any more of these. I don't think there's anything we could do with this one now.
I'm not legal, but oftentimes they'll send that letter of warning. We'll give them a cease and desist, and we'll say, if you're doing this because you don't know, then these are the statutes for that, and if you are doing that, stop it. That's kind of what that's for. But if not, then there's no reason to go any further unless there's more information. So that's typically what the intent of that is.
Okay. $43. I think that the underlying problem is he's still trying to collect without a license, or he tried to collect without a license. So $500.
Is the respondent licensed now?
I
Doesn't
don't
say
know. I remember it's a New York agency because I actually talked with them. But when I finally was able to,
So it is an actual agency?
It is an actual agency.
Oh, okay, then, yeah, I'm good. If it's really an agency and not, okay.
So we know it's an agency, so fine.
They just need to get a license in Tennessee to call it here, yeah.
Those Buffalo agencies are, I don't know if this guy's from Buffalo or not.
And like this was
Probably.
like right in the middle of Manhattan.
Okay.
When based on the dialect.
It maybe ought to be $1,000 fine. Come on, I only kidding. We walked that off the,
Policy director gets in trouble for that one, huh?
okay. That's all I have. Steve, I'm surprised that you haven't.
I read through, and the only thing I noticed is we just weren't charging enough, and that kind of bothered me, but none of them really hit me hard this time. I don't know why.
Yeah, I'd make a recommendation for a motion to approve the legal report with changes.
Sorry to interrupt for a second. Does the legal want to read the numbers into record, perhaps, or except for the one that they're going to represent, just for the record, so that we know that
That's usually what we do, yeah.
Sure.
What I'll do is I'll just read through the ones that are not that are just being presented for the first time. So that'll be 1 through 41. Right. 2017-06-5751, 2017-07-1841, 2017-07-2581, 2017-07-2641, 2017-07-2681, 2017-07-2971, 2017-07-3131, 2017-07-3531, 2017-07-3611, 2017-07-4531, 2017-07-6461, 2017-07-2051, 2017-07-01, 2017-07-7861, 2017-07-8271, 2017-07-9101, 2017-07-9031, 2017-07-9231, 2017-08-1661, 2017-08-1701, 2017-08-1751, 2017-08-1801, 2017-08-2011, 2017-08-2141, 2017-08-2351, 2018-0000021, 2018-00071, 2018-0002221, 2018-001481, 2018-002231, 2018-002901, 2018-003051, 2018-004051, 2018-004461, 2018-004831, 2018-004851, 2018-005531, 2018-005851, 2018-007961. And that concludes the case presented, not to be represented.
Thank you, sir. A motion to approve the legal report as read with changes.
So moved.
Second.
All in favor, say aye.
Aye.
New business, other business?
Just a quick reminder, of course, June meeting will be canceled. As from that exhaustive report there, you now know why that was made possible, and we appreciate legal's
Thank you
work on
very
that.
much. That's hard work there.
Yeah, sure was. Thank you, guys. Then, and we'll put a notice on the website as well to that effect, so we know that we'll all be set for August 8th. Just as informational purposes, we covered it in the the last meeting, but Mr. Howard, you were pulled away to go to the Hill and to represent the board, and for that we appreciate that. But I'll just give you the information since you weren't present for that. We talked about bond requirements, perhaps raising the bond requirement, and then the board asked that I just research the surrounding area. And upon looking at all the states that touch us, the short of the long is this: Alabama, Georgia, Kentucky, Mississippi, Missouri have no bond at all. That's kind of surprised me, actually. I didn't suspect that would be the case, but they don't. Arkansas averages about 5,000 less than our current bond requirements, and Virginia is about 10,000 less than our current requirements. They just have one flat bond. Once you exceed a certain amount, then everyone just gets 5,000. Period. North Carolina was about 5,000 more, but other than that, we're in probably, as far as it goes, we're probably in pretty good stead. And then another I think benefit of MLS is we can mitigate some of that exposure if we're getting access to everyone else's information. We don't want to obviously necessarily open up that for discussion again. I think we've done a pretty good job of bouncing off one another and going through there, but without necessarily revisiting all that. But I do see that we're about in pretty good parity.
To what extent have we actually received funds from bonding in this situation? Have we ever actually made a claim against a bond?
Not in recent memory.
I don't
Long-term
think-
memory? Have we ever done that?
I'm not sure that it would be us, our board, that makes a claim against a bonding company. I believe that would be up to the client.
It is. Mm-hmm. It is. We wouldn't take that initiative. It would be the client that would do that.
I think it seems to me that in one of our meetings ago, we talked about what the collection rate is on our consent orders and our fines. Is how many people pay, how many people don't, how much money is owed, and so forth. Have we gotten to work on that?
I've got something for you.
Oh,
I'm glad you asked.
Aren't
yeah.
you something, Glenn?
You requested a tally of what penalties were imposed for fiscal year 2017. I had operations pull that number, and surprisingly, it was pretty low. I think we probably levied as much today as we did in 2017, and it was $3,000 is all we assessed in 2017. I was surprised. I looked at the numbers several times because I thought surely we assess a lot more than that, right? But I think what we did was we assessed more smaller increments, and so anyway, that's 3,000. So
How much of that was collected?
oh, as far as collected, it was increment. Wasn't much.
Yeah, well, actually, I would say if we haven't gone to hearing on it, I'd imagine that it was either closed or sent to collections.
Does our board have a collections agency that we use to collect these?
Division of Regulatory Boards uses the same agency, yeah. I keep looking at the paralegal because she's the one that handles all that, so.
So these, the $3,000, of that $3,000, we don't know how much of it was paid?
No, sir.
Okay.
I'm not aware.
If an agency that's licensed hasn't paid their fine,
Why do they still have a license?
bingo. We need to know that. And if it's an unlicensed actor and hadn't paid the fine, we have limited
Right, and at
recourse.
that point, what we would do, we would proceed with a formal hearing and look at revocation at that point.
So we actually do pay attention. If they don't pay their fine on a timely basis, why even place it for collection? Why not just
And we
pull their
can't
license?
place anything for collection unless we have a signed agreement to pay. If we've sent them the consent order, that's a proposed settlement. If they don't sign that settlement, then it has to come to a hearing. And it's only after we have a signed order that we can send something for collection. So if we've assessed a penalty and they did not pay, we would come back to you all for a formal hearing.
I don't recall any formal hearings being requested.
Right.
It's been years and years since we've had any formal hearings.
And that's why I say it's either that they've paid or they signed the consent order to pay and didn't, and it was sent to collections.
If they sign the consent order and don't pay, then it goes to collection.
Right.
If they don't
I'd
sign-
rather have it come to a hearing if they don't pay.
Yeah.
I mean, if they don't pay, why do we send, we need to kick them out if they're not going to pay something they can agree to, for heaven's sakes. They're collection
I
agencies.
was going to say, the only way we can take the license is to have the formal hearing unless they just, do it what's called a voluntary revocation,
But-
which,
But why go to collections? If somebody's signed and agreed to pay and doesn't pay, I don't think we need to take the step to collections, personally. I think
Agree.
we just need to have them come on down and have a chat with us. Or we get their license back.
At that point, I believe we'd have to establish a second complaint.
right. Or you could just tweak the language in the consent order, I think, to say that until
Failure to pay
the civil
result-
penalty is satisfied in full, the state's under no obligation to consider this to be a final, it's not final. We could still just say, okay, you didn't pay, so we're just going to file a,
Pay constitutes revocation of the license if they sign it.
right.
If they don't pay, it's pretty obvious it's not settled. Why do we even have to say that? I mean, it's fine to say it, but that's kind of an understood. You don't pay me, you still owe me. If you don't,
Some people will make the argument that if they signed it, that
Indicates an intent.
that indicates an intent to close it. But that's why we always put in there.
and if a
that-
collection agency made that argument, we ought to fire them anyway. That's absurd for a collection agency. We
And that's
we
what
know
Dennis
they
and I were
do.
just discussing. Maybe we put language in the consent order that says, failing to pay results in automatic revocation of the license. And then that way we don't even have to have the hearing. If they sign the consent order and say they're going to pay and they don't, then we can automatically revoke the license. If they've already signed that, then they know that's going to happen because they didn't pay.
Say it on a timely basis within so many days. You've got to give a time frame before you pull it. Non-payment within 60 days or 30 days
Yeah, 30 days would be.
is considered
yeah.
revocation of your license.
I think what concerns me is that we don't know. We don't know how many signed and didn't pay, or how many paid or how many paid but didn't sign. We don't know where we are. I just know, in my mind, it's been over 10 years since we've had a formal hearing. So I'm thinking that maybe there's a slip up, or not a slip up,
Disconnect.
a disconnect that we're not proceeding on with our
Legal, they offered one option with the language and the agreed order automatic revocation. That would save a lot of time and money as well because really the issue in a formal hearing is whether or not they paid. Well, we know if they paid or not. So, why get all dressed up with an administrative law judge and a court clerk for us to show the balance? Our court reporter, thank you. So I actually have that board. That's shameful that I didn't get that right. But but that's, if it was just automatic, that would give us at least some teeth for follow-up administratively. I think maybe that's the disconnect, is just put that language in there.
Anybody we've sent to an agency, we need to find out what we sent them for and send them another letter and say, we're bringing you up for a formal hearing if you don't pay this, which will result in your license being suspended or pulled. Because that is total disrespect for the license and our board. If they say, I'll pay you and don't pay, or if they just ignore the fine.
The end result, though, you would want a revocation of that license, right? So if we could do it without the formal hearing, though, and get the same end result, though,
Sure.
That might be
I'd
helpful.
sure want their attention.
Yeah, it's
Yeah.
just, yeah.
I think I'm fine with that going forward, but what about all these people that haven't paid in the past?
And Carol just brought up a good point. She said when that happens, if they are sent to collections, we flag that license file in our system, and if they come up for renewal and they submit their renewal application, there's a stop point there that they have to settle that complaint before we issue that renewal.
Oh, okay.
Well, if they don't want to come up for renewal.
I still don't think we should renew them. If they're going to disrespect the board enough not to pay a fine they agreed to pay, they don't need to have a license.
Right, and like I said, from our end, we would say that they have to settle that complaint before renewing. But if that's something that you want to know before issuing that renewal, I think that's something that you all need to.
I'm saying I
direct
wouldn't
to
wait
Dennis.
long. I wouldn't wait for the renewal. It could be 12, 18 months before it's done. I think you just need to go ahead and take the rug out from under them. If they're not going to pay enough attention to the rules to break them, agree to a fine, don't pay the fine, that's just, why do we think they're going to do what they're supposed to do otherwise?
Right.
They don't
And-
need to be licensed.
And like I said, I agree with you on a go for it, like Ms. Hoover said. I'm just trying to think how to implement that for signed orders or orders that we've already sent to collections. I'll have to do some thinking and talking on that one.
That is one big data dump. As of this date, anything hadn't been paid, we send this out, and here it is.
I'll have to look into that. And what I'll do is additionally, I know you were asking about the collections versus what was settled by consent order. I'll look into that and then give that information to Glenn, and he can send it out to you all as well.
Well, I think it's important we know where of the people that we sent these consent orders to in 2017, where do they stand? Who's paid and who hadn't paid? It's not the money as much as it is them agreeing to the procedure. And I, for one, if I signed a consent order, I'd send in the money. So I don't know where we are. That is the point. I don't know, and
Right.
this board doesn't know.
I think that's why the tally of the collections was a little fuzzy, because when I was asking around about that, it's because they are going to collections, and so that's not in-house, and so we can't just pull that from core, and so I think that was probably the issue there. Now I'm starting to be able to put those pieces together now.
Maybe we ought to have a report from the collection agency. I mean, collection agencies. When I owned my agency, I gave those reports all the time. Where do you stand on this account, that account, and so forth? A status report of our accounts.
If we get that status report, my position is we should go one step further. Pull them all back from the agency and get rid of them if they hadn't paid.
Right.
Unlicense them. Make them aware of the fact that they can't do that in the state.
Yeah, it's like if I had a car payment.
Penalize the absolute fool out of them for not paying. Every 30 days you don't pay, it doubles.
I don't think we have that authority, but
wish we did.
yeah, well,
That's, the fact that, a potential collection agency wouldn't make their own payment, but then would turn around and collect from other folks, right?
yeah,
Yeah.
Unbelievable.
yeah, unbelievable.
Well, it's an insult to the licensing. The licensing doesn't matter to them. It's just something they have to do as opposed to pay attention to.
It's an insult
Ain't
to
right.
those agencies that are paying, that are doing
Yeah.
the right thing. That these agencies don't do the right thing, then they get a consent order and a fine, and they don't.
I think we have a way forward. Then we have a couple items. One is we'll look into the status report from the collection agency. So I think that's one option. So we'll know where we stand.
Right.
And then that's one. The other, and legal's looking into this too, the agreed citation language, where it's just automatic revocation. So we're not, doing a formal hearing, because the end result of that is a revocation. If we can skip that and get a revocation, that even better, So we'll look in those two items and then have something to report then. Okay. Unless someone else has new business, that was all we had.
Any other new business?
No.
Recommend we adjourn.
So moved.
Second.
All in favor?
Aye.
To realize the audacity.
She's been here about a little over a year, right?
Been here since May.
Maybe more than
I'm
10.
kind of shocked by
I've been
that.
on this for
I've never
15
seen
years.
Right, exactly.